The day began with a complication. Defendant Dion Richmond was nowhere to be seen. His lawyer explained he'd been extradited to Ohio, sitting in a county jail miles away. The judge listened carefully, then granted an adjournment. Justice delayed, but not denied, because even across state lines, the law keeps its reach.
Right, but if he was extradited from Michigan to Ohio, I'm going to assume, looking at this charge, that charge is probably more serious.
It is, Your Honor. I believe it to be a failure to register allegation, where I've been in touch with defense counsel relating to him having an upcoming court date there on 10/17. I'm optimistic that we can resolve this in between now and then if we could be adjourned to a date after that.
After 10/17.
Yes, sir.
Okay. Preliminary examination will be adjourned October 21st, 2025. 9 a.m. That's before me. Bond continued.
Thank you.
Court does call the case of the People versus Jimmy Lee Murray.
Roger Green for the defendant, Your Honor. We're ready to proceed.
Your Honor, at this time, people would request an adjournment, a couple reasons. One, on case number 25 FB 1371 FY. That case is charged incorrectly, to my belief. I don't believe we can proceed. We could proceed on count 2 because as it's charged, it was not illegal on July 2023.
Pardon?
Count 2 were abandoned
On that case.
on that case.
Okay.
I did speak to Mr. Green, informed him of my intention to add a count 4 on 25 FB 2 FY, that being weapons, firearm possession by a prohibited person, because on that particular date it was.
Next, tension rises when the prosecutor admits yet another charging error. The judge, visibly frustrated, reminds the courtroom that this is the 4th or 5th case with the same problem. His patience wears thin, and after reviewing the facts, he dismisses the case altogether, sending a strong message about precision and accountability.
Additionally, I was going to be able to start the exam, possibly get through it on 25 FB 1372. After conversations with Mr. Green, I apparently misunderstood that his client was going to waive the exams based on our conversations. And I let the officer go with that for 20 some odd hours at that point. The officer who was involved, 25 FB 1371, was not here. I don't know if he got notification to come because it was his partner who was here and they both worked last night. That's why I'm asking for adjournment.
But on 1371,
Yes.
count, just dealing with that case, count 2 is improperly charged, and you couldn't have proceeded today on count 1 because the witness wasn't here. On that matter, Mr. Green's motion to dismiss is granted. I'm dismissing that case.
Thank you, Your Honor.
Now, in the other case, you want me to adjourn it so you can add an account, and Mr. Green wants it waived. This one, correct, Mr. Green?
No, I don't. Asking for an exam on this one as well. I'm not asking for a
Today
waiver.
or no?
Beg your pardon?
On case ending in 1372, are you asking for an exam on that one?
No, he's asking for the, I'm asking for a dismissal.
You know, there are some days I'm sitting up here and after a long morning, it feels like everybody's talking French to me. I'm just trying to understand. I thought, Mr. Jablowski, you indicated that on that case, 1372, that you were considering adding a count 4.
And actually, unfortunately, amending.
Pardon?
And amending count 3. But one of the officers was here. I cut him loose based on our conversations. I misunderstood Mr. Green clearly. So that officer.
And you understood that you thought he was waiving. That's where I'm getting that in my head.
Yes,
But you were going for the exam.
I misunderstood.
That is correct, and it's my understanding. It's also my understanding that there were two witnesses that were necessary on this case, and only one was available. So it's my understanding that the prosecutor was going to ask for an adjournment anyway. Is that correct, counsel?
When we started our conversation, Judge, I pointed out the issue.
Because there was
that I
some-
saw with both cases to Mr. Green. And I said, I would like to ask for a adjournment on both. We'll get it cleaned up. Get it back in front of the court and in court. They know what they're offending against. That's what I initially said, but the officer was still here at the time. And
The officer that's on 1372.
yes, the 1372 officer, who I believe I know I could have gotten through part of the exam. I may have been able to get through all of it.
Based upon the unreadiness of the prosecutor, I asked for dismissal on this case as well, Your Honor.
I'm going to deny that request and I'm going to adjourn it because here's the reality. Had there been a meeting of the minds as you need to hands on your pockets. Had there been a meeting of the minds as to what was actually transpiring, prosecutor's position would have been different in that the prosecutor, if you guys had asked me at that moment and the officer were still present, they could start and then I would have adjourned it anyway.
I understand.
Right. So on that case, I will grant the adjournment of the preliminary examination, having dismissed the other one. I will set this preliminary examination for October 21st, 2025 at 9 a.m. That's before me.
Thank you.
Thank you very much, Your Honor.
Thank
Bond
you.
continue.
Bond continued. Thank you.
Thank you very much.
Finally, a rare moment of integrity, the prosecutor voluntarily dismisses the case against Dennis Link, admitting the evidence was weak. The judge commends the honesty, a refreshing reminder that justice isn't about winning, it's about doing what's right.
Your Honor, I would like to say, that I'll take the opportunity for the record to say that this was a relatively minor allegation. Mountain controversy was just barely over $200. It was enhanced to a felony based off of a prior conviction.
Yes.
I had evidentiary issues relating to proving it. It's an older file where once I learned that Mr. Link is currently in custody in Oakland County, he was recently sentenced to 365 days in jail. I believe the interests of justice are best served by dismissing this case today, even in his absence.
And you have no objection.
I have none, Your Honor.
Yeah, had to put emphasis on that. All right, case is dismissed.
Thank you, Your Honor.
You're welcome. Court calls the case, People versus Jacqueline Waitsville.
Good afternoon, Your Honor. Paul Stablin appearing on behalf and with Ms. Waitzel, who stands to my right.
And she's waving.
Judge, we have discussed her rights in regard to a preliminary examination. Ms. Waitzel understands those. She's executed the form about her understanding, Your Honor, and she intends to waive her right to have a preliminary examination, have the matter bound over to the circuit court as charged.
Is all of that correct, ma'am?
Yes, Your Honor.
All right. People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all three counts.
In regard to arraignment, Judge, Ms. Waitzel would stand mute. I'd acknowledge receipt of the general information, waive its formal reading. Ms. Waitzel would stand mute. I'd ask the court to enter a not guilty plea on her behalf.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all counts. Pretrial in this matter will be set for
December 3rd at 1:30.
December 3rd, 2025, 1:30 before Judge Conlon.
Very good. Thank you very much. Your
Thank
Honor.
you. Bond will continue.
Thank you.
That's all.
That's all you have.
She's not here.
Yes, no, and I don't have any tea.
Okay. The only thing that I have left then is the coffee banner. The witness I don't know, how many witnesses were you anticipating on that?
2 or 3.
2 or 3. Okay. I know one of the witnesses is in custody. They are not present currently at the facility here. We were informed that they had a court hearing down before Judge Slay. Because of all of that, we indicated that they could take him to Judge Slay and then come here, and then we would begin. We did that in anticipation that I'd be doing something else, but this is all I have.
Judge, may we approach?
May we approach, Your Honor?
Oh, boy. You may be seated. Court does call the people of the state of Michigan versus Christopher Coffey.
Alex Chabalowski, the people here.
Good afternoon, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Coffey, who approaches to my right.
Good afternoon, Your Honor. Good afternoon. All right, we have been in discussions regarding and I'll just try to summarize it in a way, that regarding this case and some interesting issues that it raises regarding, in this court's mind, ownership, which could lead to, I guess, different conclusions as to how one may conclude the matter, or at least view this matter. This court certainly not wanting to render a judgment in error, would think that at least at this juncture, without at least some further discussion, that it is not appropriate to begin testimony. There is because, just so for the purposes of the record, there is a decedent who may have, prior to their death, given the defendant a certain piece of property. Were that not the case, or if it's not the case, that property, I think it may be agreed between the parties, would have passed intestate to the 2 named victims. That may very well mean, and the court doesn't know, that ownership could be a question of fact, or it could mean that there is no ownership until such time as any dispute over that piece of property were settled by the probate court. And certainly I would give counsel time and would hear additional argument as it regards that. And hopefully this matter, since it involves a family matter, can be resolved. But if not, then the court will hear it. But to give time for all of that, everybody's in agreement to adjourn this matter. I'm going to give some additional time because it just scheduled alleged vacations. Well, I say alleged vacations for me. That may happen, as well as the holidays. So I will adjourn this December 1. Okay. I will adjourn this matter to a special time of December 1 at 9 a.m. Counsel had asked, and I would, and the court believes that's appropriate, so that the individuals aren't coming down here waiting through a docket.
Your Honor,
You're kidding me, man. No, I'm kidding.
I didn't realize that was right after Thanksgiving, and I usually am out of.
December is always right after Thanksgiving.
I was hoping we had that week between and I'd be here, but it's not.
Is it? December 15th at 9?
That's fine.
Still after Thanksgiving.
I could do the
But
second.
not so close to Christmas.
I could do the second if it works. It's just the first won't.
Okay. Why don't we just
9 o'clock.
I'll do December 15th. All right.
Thank you, Your Honor.
So preliminary examination will be adjourned December 15th, 2025, 9 a.m. That's a special time that is before me.
Thank you, Your Honor.
And Mr. Coffey, since this is you've talked with your attorney, I'm sure. Did you have any questions for the court as to why the court's doing this?
No, Your Honor. Nope.
You understand?
Yes.
Okay, very good. All right.
And Your Honor, if I may,
Yes.
I'd just like to acknowledge that I'm in receipt of the copies of some text message, and I believe they've been provided to the prosecution as well,
Yes.
that your staff so graciously provided.
Yes.
Thank you, Your Honor.
Thank you. They're a good group of people. They're okay. All right. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
14A. Stands adjourned.